Lahore High Court. They failed to do so. Therefore, they continued to be on the rule.
So,
by a deeming fiction.
At that time, the definition of advocate under Rule 8 and the order which was shown clearly permitted advocates to also be in service. So the Honorable Court said that they are advocates, and it goes on to say that our... Kindly see that again, I'll show that in a moment. And thereafter, it is in any case completely clinched by Chandra Mohan, which after considering Rameshwar Dayal says specifically that service was not an issue there. It has not been decided. Rameshwar Dayal is interpreted and considered in Chandra Mohan, and Chandra Mohan says that Rameshwar Dayal's case is not based on service, is says so in so many words, Yes. So that's the answer in brief, but of course I'll show them as well. Now, let's kindly see the discussion here in the Constituent Assembly debates. Kindly see Honorable Dr. B.R. Ambedkar, chapter so-and-so, 209A, 1 and 2 are placed. Kindly turn the page over, page 46. And kindly see the foot of page 46, Shri Kuldhar Chaliya. Mr. President, sir, I beg to move that in amendment number 20 above, in clause 2 of the proposed new article 209A, after the words 7 years and pleader, the words enrolled as and of the High Court of the state or states exercising jurisdiction may be inserted respectively. I'll just pause, just see the top of the page. Your Lordship sees the words years. So the suggestion was after years, say enrolled as an advocate or a pleader, and then add of the High Court of the state or states and is recommended. This was the proposal. Sir, the object of this amendment is that unless a lawyer has practiced in the same province in which he is going to be appointed as a judge, it will be very difficult for him to appreciate the customs, manners, practices of the country. We have in our country strange results from the appointment of so-and-so. So also in cases where officers from outside the province were brought in, I am not limiting thereby the enrollment of advocates from any province. They may come and practice. Only I am saying that he should have resided, etc. Now just see the last 4-5 lines, of before Dr. Ambedkar's passage starts. I have not prevented any man from coming from any other province and practicing in the High Court of the province. The only thing I insist is that they should live there for 7 years so that they may be acquainted with the customs in the country to become eligible for appointment as district judges. Then Dr. Ambedkar says, with regard to the observation of the last speaker, I should like to say that this chapter will be part of so-and-so. Then the next para, there are 2 amendments, one by Mr. Chaliha and the other by Pandit Kunzuru, which call for some explanation. With regard to the amendment moved by Mr. Chaliha, I am sorry to say I cannot accept it for 2 reasons. One is that we do not want to introduce any kind of provincialism by law as he wishes to do by his amendment. Secondly, the adoption of his amendment might create difficulties for the province itself, because it may not be possible to find a pleader who might technically have the qualifications, but in substance may not be fitted to be appointed to the High Court. And I think it is much better to leave the ground perfectly open to the authority to make such appointment, provided the incumbent has the qualification. I therefore cannot accept the amendment. So, the understanding was, bar alone, in my understanding, they're not talking, otherwise he'll say, the answer would be, well, you'll have people from the services, bar, and they say, no, we will not restrict it, and therefore let it be open to everybody. Don't bring it only to that province. Then, at page 48, just above where the Mr. President, the question is, in amendment so-and-so, so-and-so, the amendment was negatived. This amendment, is rejected for this reason. Now, kindly see first, before I proceed further with my submission, kindly take, for a moment, the Shetty Commission, which your Lordship will find, at page, in volume 4, at page 612.
649.
It's also there. I want to show 605, I'm sorry. It's also there earlier.
It's in the volume V7.
Well, I want to show the part which is earlier, if your Lordship, I'm sorry. 605 minutes. That's there as well.
City Commission, page 6499.
I'm at volume 4A and 4R. 605. Page. That's right. That's all right. That's all right.
Yes.
Your Lordship will see at page 605, starting with whether the lower judicial service, my lords have that, right at the top,
Yes.
my lord the Chief Justice also has that, whether the lower judicial service personnel would be made eligible for direct recruitment to the post of
You are at 605.
I'm at 605
Whether the law judicial.
Yes, yes. Whether the lower judicial service personnel could be made eligible for direct recruitment to the post of district judges. The Constitution as it stands does not provide for consideration of persons who are already in judicial service for direct recruitment to the cadre of so-and-so. This is the understanding, and then this is the understanding. Then they quote the article. Then they quote Rameshwar Dayal, Chandra Mohan, and Satya Narayan, etc. They quote all that and kindly come to 608. Question number 8.3. Do you think that the officers in the lower judicial service should be allowed to compete for direct recruitment to the district judge cadre? If so, what should be the experience in service for such officers and how Article 233 of the Constitution of India should be amended? Explanation AA to sub-article so-and-so may be noted in this context. Then Your Lordship may skip the next few pages and come to page 612. And please see, the paragraph 11.41, Constitution Amendment proposed. Following amendment to Article 233(2) of the Constitution has been proposed. Then, they notice the stands of various high courts, Punjab Haryana High Court, Bombay High Court, the page over, Calcutta, Allahabad, Bihar, Judicial Service. All of them saying delete this word, add that, etc. All these suggestions are being given. And if Your Lordship will then come, to the final conclusion at page 617. 617, para 11.67. We accordingly suggest that clause 2 of Article 233 be substituted with the following clause. A person shall be eligible to be appointed directly as district judge if he has been for not less than 7 years an advocate or held judicial office in the territory of India and is recommended by the High Court for appointment. We propose so-and-so. Then 11.69 is important. We request the central government, all High Court, state government, administration unit to take immediate action for amending clause so-and-so as indicated by us. So, the clear understanding was that 233(2) as it stands does not permit And various high courts, all of them are suggesting various things, but this is the conclusion. This amendment is required. Yeah. Take too much time on that.
So interpretation as given to 233 in Satya Narayan C.
And Rameshwar Dayal and Chandra Mohan.
Absolutely right.
And this, yes, of course, after referring to all of that, after referring, this is the interpretation. I agree with this. After referring to all the judgments, including Satya Narayan, of course.
Yes, in any case, these are recommendations.
I agree. I'm only trying to, even the debates, are not in any way, they take.
Constituent Assembly debates are relevant for the purpose.
Of course, even this is relevant. Even this is relevant because Shetty Commission has proceeded on a premise. I'm not saying.
See, judgments are based upon the recommendation of the Shetty Commission.
Yes, yes. Now, now kindly come back to my note, I have it thereafter, I have referred to Rameshwar Dayal and then Chandra Mohan at page, back in my submissions, page 48, 49 to the top of page 50. In volume 2 of my written submissions, should I now place Rameshwar Dayal one more time, if
Yes, we have.
yes, 1960. If your lordship will again take Rameshwar Dayal. Page 98 of the judgment volume. Volume 1, 5.1.
We have that.
5.1. Page 7. I will just very briefly restate my understanding of Rameshwar Dayal. As I said yesterday, 233(1) and 2 both speak of appointments. 233(1) specifically uses the expression promotion. What the purport of that is, we will see. 230.
Postings also.
Posting also.
Also uses word posting. Appointment posting.
Yes.
So even direct appointing with an advocate, the source of appointment would be 233(1) only. Because after appointment, he will have to be posted.
Your lordships have interpreted.
Otherwise, it will have a disastrous consequence. We'll tell you why. Because 233(1) says, the governor in consultation with the High Court. That applies to appointment and promotion and posting, everything. It can't be in piecemeal.
Your lordships have interpreted posting and promotion to mean that posting here refers to the first posting after promotion.
No, what about appointment?
Well,
after appointment, would not there be a first posting?
yes, Manas.
Or he's only appointed as a district judge in the state of Maharashtra. Is that sufficient?
No, Manas. Of course, Manas. My submission is this. Clause 1 is talking about promotion. Clause 2 is clearly referring to direct recruitment.
No. Clause 1 is also talking about appointment also.
Manas, yes, Manas, of course. Manas, I'm saying, Manas.
Then how is the appointment to be made for direct recruitment?
Manas, clause 2.
That's not under clause 1 only, because governor in consultation with the High Court only can be done.
Yes, Manas.
You can't read it in piecemeal like this.
Manas, clause
It doesn't
2.
make any sense otherwise.
Clause 2 is also constitution. Clause 2 is also talking of appointment, Manas.
No, clause 2 says, for eligibility, a recommendation should be there. Clause 1 says how an appointment should be made. Appointment should be made by the governor in consultation with the High Court. That applies when somebody is come on promotion, somebody comes on the direct recruit, thereafter the posting.
Let us see, Manas. Let us see.
What we are tell you is that if your argument is accepted, if you remove you from clause 1, how are you appointed then?
Manas, may I kindly I'm not saying that, Manas. Kindly see 233(2) again. Person not already in service.
No, see 233(1) also.
Yes. Appointment of persons to be and the posting and promotion of district judges in any state shall be made by the governor of the state in consultation with the High Court exercising jurisdiction in relation to such state. Now, 2, a person not already in the service of the union or of the state shall only be eligible to be appointed a district judge if he has been for not less than 7 years an advocate or a pleader and is recommended by the High Court for appointment. Now, my submission is that when 2 speaks of not already in service.
That's also interpretation. It all depends in what way to interpret it.
Now,
because the placing of that would also be relevant.
Yes, I agree, Malas. Now, my submission is
Your submission, you are right in submission.
My submission.
Your submission is 233(2) is exclusively meant for an advocate who has 7 years practice.
Now, if it were not so, the result will be that 1, we are reading into 2 what is not there. It does not specifically say this is for in service. It doesn't say that. So we are reading into two what is not there. Number two, we are going to prescribe a qualification for them which is not there. Number three, we are contemplating adding 3, 4, etc., which is not there.
Interpreted by Rameshwar Dayal and Chandra Mohan that sub-article 2 provides a qualification for the persons who are already not in service. It provides a qualification for lawyers. If you are a lawyer, then you must have a 7 years practice. It does not provide for a qualification insofar as in-service candidates are concerned. It nowhere says that 233(2) is not available to in-service candidates.
Well, it's where Rameshwar Dayal and Chandra Mohan say that 233.
So therefore, it is better that you take us to Rameshwar Dayal and Chandra Mohan.
Very well. Very well.
So that you can buttress your submissions.
Very well.
On the basis of findings,
Very well.
we will have to consider whether their interpretation of Rameshwar Dayal and Chandra Mohan is correct.
Very
and your interpretation is correct.
Very well. Highly kind.
Or we are required to give some third interpretation to it. We are not bound to accept their entire argument, neither your entire argument.
No, absolutely. Absolutely.
You might find that the third interpretation is a more correct interpretation.
Yes, as long as it's within the 3 constitution bench judgments.
Yes, it is.
Of course.
We can't travel.
Yes.
If we disagree with any of the constitutional benches, the only option available is
To go to 7.
to go to 7.
Yes, I agree, Milids. Now, Milids, let us see Rameshwar Dayal once again.
Yes, please.
And please see, Milids, I'll be very quick because I'm running out of time again, Milids, but I have a lot to cover. So kindly come.
Okay, you take to on your time now.
Yes. So, Milids, at 104. Like so many overs, Milids, and so many. Like so many overs, Milids, and so many runs to score.
You are confident.
At 104 Milids in to score.
You are confident.
At 104 Milids in 5.1, in 5.1, volume 5.1.
By let's to start from 103.
Last sentence.
Right.
Yes.
Sani, PR Sani, the last sentence.
Yes.
Or you can read from para 5.
Para 5. Respondent Sani was called to the bar on 17 November 30, was enrolled as an advocate so-and-so. After partition, he shifted to Delhi and worked for some time as legal advisor to so-and-so. He practiced for some time at Delhi, then accepted service under so-and-so. On March 30, 1949, he became chairman Improvement Trust. May 6, 49, he got his license to practice as an advocate suspended. On April 6, 57, he was appointed district session judge. It would thus appear.
Just one question.
Yes.
I think Bar Council, somebody is representing Bar Council also. Mr. Gupta was there for Bar Council of No. So on a judicial officer being appointed as a civil judge, junior division or whatever it is, whether he stands suspended or cancelled.
Perhaps so.
Therefore,
But when you still check it, yes.
to my understanding, it is suspended.
Yes.
And it revised the moment he demitted his office.
Yes. It should be.
Unfortunately, that's not available for us.
I'm sorry, Milids.
Unfortunately, that advantage is not available for all 5 of us.
We don't know whether it's unfortunate or fortunate.
Even if you retire as High Court judge, your son revives.
Yes, of course.
We get so many applications for retired judges for designations.
Absolutely.
2 of them appearing on either side in this way.
So,
I do the Patwalia.
why do you forget Mr. Giri? Mr. Giri? No, Mr. Marlapalli is on a different pedestal. Mr. Marlapalli completed his entire tenure and then joined the bar. All 3 of them for different reasons. Mr. Giri, Mr. Naidu, and Mr. Patwalia.
But they're all on that side with us.
Well, Mr. Patwalia jumped the right side at the right moment. But the on being appointed, the Sarath stands only suspended. No, not cancelled. But it can be revived. On demission of office on application, it revives.
As I was saying, Malad, they're all on that side.
Because they have experience of the working of the High Court.
Yes. Now, Malad,
Mr. Marrapalle has a longest experience because he was associated with that so many administrative committees.
yes. Kindly come to 106.
And Mr. Marrapalle and me both repent for a wrong decision we had taken in 2008.
It's not doubly blessed, Lord, they have the vacancies twice. Lord, say, Mr. Giri, Mr. Patwali and Mr. Naidu have been doubly blessed.
Yes. Why do you say doubly?
It should be triply or
In multiplicity.
yes, sir.
Yes.
Now, let's kindly come to to page 106. 106 minutes.
So you wanted to read 104.
Well, that's all right. I'm short on time, so I'll just quickly make the point, Malad, then go to Chandramohan. Now, 880, page 106, clause 6.1 is noticed. Thereafter, Malad, at 107, section 8 is noticed.
Section 18 of the Bar Council Act.
I'm sorry, Malad.
Section
Yes.
18 of the Bar Council Act.
Yes, Malad. Yes, Malad. And I'll show Malad how it stands today. Then now come Malad to page 110. Malad, till about 10 lines from the bottom is regarding 124.217. I made the point, I won't repeat that. Kindly come to this part starting Article 233. Till there, Malad, it's on 124.217. That point is made, Malad. I'll move further. 233 is a self-contained provision regarding appointment of district judges. I just pause, Malad. My understanding is, as expounded, this has been further clarified in Balmukund, that it's complete. You don't need to.
Therefore, but not 233.2. 233.1 read with 2 is a complete code.
Yes, but Malad, whether we should then read into it, Malad, that it means also in service and then provide a qualification. So that's from that standpoint, I say, Malad, it's self-contained. And if we have to put so much into it, then obviously it's not self-contained, Malad.
Then we have to decide whether we have
of course,
whether we have to put something or which is already there.
Yes, Malad. Then, Malad, as to a person who is already in service of the union or the state, no special qualifications are laid down in clause so-and-so. The governor can appoint such a person as a district judge in consultation with the relevant high court. As to a person not in service, qualification laid down in clause 2, and all that is required, he should be an advocate or pleader of 7 years standing. The clause does not say how that standing must be reckoned, and if an advocate of Punjab High Court is entitled to count the period of his practice in Lahore High Court for determining standing at the bar, we see nothing in 233 which may lead to the exclusion of the period for determining eligibility for appointment. Then, Malads, on the same page, at the foot of the page, here they are dealing with the other 3 gentlemen, Malads, who were continuing to be advocates, and they say they are clearly eligible under 233.
One of them, the most eminent judges
of course, Malads, of course, absolutely, Malads. Then, Malads, the page over at 888.112, the entire discussion on the rule and the clause starts, section 8 and Malads clause 2. That whole discussion goes down, and at the foot of page 112, Malads.
They did not cease to be advocates.
Yes, ma'am. So they did not cease to be advocates at any time or stage after August 1547, and they continue to be advocates of the Punjab High Court till they were appointed as district judges. They also had the necessary standing of 7 years to be eligible. These conclusions really dispose of the appeal. We may state, however, there is that an alternative argument based on so-and-so, about 5 lines down, as we are resting our decision on conclusions drawn from the High Court Order 47 and Section 8 of Bar Council Act, we consider it unnecessary to examine, sir. So their decision here, Malads, is based on their being advocates and not in service. And that is what Chandramohan interprets Rameshwar Dayal to be. Chandramohan says in so many words that this decision is premised on their being advocates, not in service. Therefore, what has fallen from your lordship?
They did not cease to be advocates. Though they were in service, they did not cease to be advocates.
So, Malads.
So therefore, again, the question would be whether a judicial officer, after being appointed as a judicial officer, ceases to be an advocate or is suspended.
So at that time,
And here also, here in Swani specifically had applied for suspension of his sanat.
here they have,
He had applied for, if you read page 103,
yes,
he had applied for suspension of his sanat.
in my understanding, here they have gone on the premise that under section 8, you continue to be an advocate. And they say in so many words that our decision is based on this. It is not based on their being in service. It is based on,
So therefore, we will also have to consider what is the provision in the Bar Council of
Now,
Advocates Act.
now, at this time, this was section 8, which did not prohibit, did not require, this was the section 8 that I placed yesterday. I will show how 49 today stands, which is the relevant provision, which has been seen. Now kindly come to Chandramohan, which your lordship will find, in the same volume at page 180. In the same volume, page 180. Kindly first come, to page 185. I'll add 103, no problem. 185, which are the arguments.
Yes.
Argument of learned counsel for the appellant may be placed conveniently under the following 5 heads. While under 233(1) of the Constitution, governor has to make appointments of persons to be and posting of so and so, so and so. I'll skip that. 2. On a fair reading of the provisions of the rules, it is manifest that the High Court is a transmitting authority, while the selection committee is made the real consultative body. That is to say, the governor has to make the appointment not in consultation with the High Court, as it should be under the Constitution, but in consultation with the committee constituted under Rule 3. Governor has no power to appoint district judges, that's 3 minutes, to appoint district judges from judicial officers as they were not members of judicial service. 4, the exclusion of members of judicial service in matter of direct recruitment offends 1416 of the Constitution. Now, they never went into 4 minutes, but they don't go into it for reasons they've stated there, which I'll show presently. But that question is...
Judicial service, which judicial service?
No, that's right. Of course, that's right. There's no doubt on that. Judicial service means judicial service, not judicial.
The judicial service, they were considering also where the executive was a part of the judicial service.
Yes, I agree. No, judicial officers and separate from judicial service, and they've explained that here. So they are under judicial service as understood by Chandramohan, and not judicial officers as understood in pre-independence. This is what Chandramohan says. That's one part. Now, please come, kindly turn the page over to page 187. But I'll remember this. Page 187. Very briefly, the rules they were considering, Rule 14(2) concerning direct recruitment, application by barristers, advocates, vakils, so-and-so should be submitted by district judge concerned and must be accompanied by certificate age of so-and-so. Applications of judicial officers should be submitted in accordance with rules so-and-so. The district judge or other officer through whom the application is submitted shall send to the court along with the application his own estimate, etc.
Therefore, these rules permitted both the judicial officers as well as the lawyers to apply for the direct recruitment.
No, kindly read. Applications from judicial officers should be submitted in accordance with rules referred to so-and-so. District judge or other officer through whom the application is submitted shall send to the court along with the application his own estimate so-and-so. Then interview. Yes.
Rule 14 refers to direct recruitment.
Yes, Manoj. Yes, Manoj.
So
applications from judicial officers should be submitted in accordance.
That rule only provides that if it is a barrister, it has to be wait through the district judge, and if it is a judicial officer, then it has to be made in accordance with Rule 2B of. So that stream is available to both.
Yeah. Now see further ahead, Manoj. That's right. Then 15 minutes. Selection committee shall scrutinize applications received by the court, require such candidates as seem best qualified for appointment, etc. So the selection committee, was doing the selection work, and your lordships then consider this on the next page at page 188. And they notice, they notice these rules, the powers of the selection committee, and kindly come to
Yes.
Kindly see the new paragraph, Malad. I rely upon this. The position in the case of district judges recruited directly from the bar is worse. Under Article 233(2) of the Constitution, the governor can only appoint advocates recommended by the High Court to the said service. But under the rules, the High Court can either endorse the recommendation of the committee or create a deadlock. The relevant rules therefore clearly contravene constitutional mandate of 233(1) and 2 of the Constitution and are therefore illegal.
So therefore,
It's
they
against
take a notice that the
233(1).
district judges, the members from the service could also be appointed directly as district judges.
Malad, they don't say that, Malad.
So the position in the case of district judges recruited from bar is the worst.
Yes. Why? Because the selection committee is doing everything. And they say 233(2) of the Constitution, governor can only appoint advocates recommended by the High Court to the said service.
They disapproved the recommendation of the committee. Said, because in that committee, they disapproved the recommendation of the committee. They said the committee cannot take the role.
Whether we put, let us see, Malad, let us
Then
see.
read the next line.
Yes,
The
yes.
relevant rules therefore clearly.
But under the rules,
contravene
the High Court can either
Constitution
endorse
of-
recommend.